Are you thinking about getting a divorce, but your spouse controls all of the family money? I'm Matt Dolan with Dolan Divorce Lawyers in Connecticut, and today I'm going to talk about how you can educate and protect yourself if your spouse controls all of your family accounts. Now, first off, there's a broad spectrum of reasons why one spouse might control all of the family money. It can be a very innocent reason in that one spouse simply has no interest in the finances and doesn't know anything about the family income or assets. Or it can be a very abusive situation where one spouse withholds money in order to get what they want. Maybe they tell the other spouse that they won't give them any money if they file for divorce, or they're going to destroy them financially if they file for divorce. No matter where you are on the spectrum, though, there are steps you can take to make sure you protect yourself. Now let's start with a more innocent situation. Hopefully, if you decide to file for divorce, your spouse, if they control the family money, will keep paying bills, will keep providing you with the money that you need, etc. And then during the divorce process, if that is the case, you can get financial disclosures from your spouse through the discovery process. So you will file motions asking for bank account statements, tax returns, etc. And both parties will also have to file with the court what are called financial affidavits, which are documents that list the income, assets, expenses, and debts. So generally speaking, there are these full financial disclosures where if you were in the dark about finances in the past, your spouse will have an obligation to disclose statements so that you can become educated on the dynamics of your family finances so that you can hopefully resolve your divorce. If your spouse does not continue to pay bills and support you financially, you will likely have to seek from the court what are called pendente lite orders. And pendente lite means during litigation. And that would be done via filing a motion for child support, alimony, contribution to household expenses, etc., seeking that there be orders in place for your spouse to pay you financially or pay household expenses while the divorce is ongoing. So from the initiation of the divorce until you are able to resolve the divorce and get final financial orders. You might also want to file a motion for counsel fees pendente lite. If you don't have the money to pay a lawyer and your spouse controls the finances, you can file this motion to get the funds to pay a retainer for a lawyer so that that lawyer can fight for you to get a fair ultimate resolution to your divorce. And if you're filing pendente lite motions, it does not necessarily mean that you are in an abusive situation. Maybe you and your spouse just can't agree for a number of reasons on what financial contributions each of you are going to make, and you need the court's help to enter order to maintain some semblance of stability during the divorce process. There can, however, be legitimately abusive situations where the other side is engaging in behavior that is considered coercive control. And coercive control in Connecticut has a very specific definition that is laid out in Connecticut General Statute Section 46B-1. Some specific examples of coercive control in the statute are depriving another family or household member of basic necessities, or controlling, regulating, or monitoring another family or household member's finances or economic resources. So if that is happening, you can file a restraining order to get immediate orders put into place. When you file the application, it is ruled on the papers by a judge where immediate orders can be put into place before a hearing, which will be held within the following 2 weeks. The pendente lite orders can take several weeks to a month to be heard. However, you have the option of filing a restraining order based on coercive control if you need that more immediate relief. And after the restraining order application, the court can enter orders for financial support to be paid to the spouse that does not control the family money. And hopefully once those orders are put into place, you can then move on with the normal discovery process of exchanging financial information and hopefully negotiating to resolve your divorce case. So in general, the advice I would give is to gather whatever financial information you can safely obtain prior to your divorce, and consult with a lawyer about the best strategy to take if you are not familiar with the finances of your family. So as usual, if you have any additional questions, I would invite you to contact our office. And if you are looking for representation in a divorce or family law matter in Connecticut, we would invite you to contact our office as well.